Good morning, everybody. It is now 10 o'clock, which means it's time for the inquiry to resume. Miss Lintop, were you expecting Mr. Dudley for the evidence of Mr. or Mr. Woods?
I was expecting Mr. Dudley, yes. And I have had a call from him saying, well, very much what Mr. Masters has been saying each day. He went home last night because obviously the timetable was that we expected to finish the landscape evidence. He's coming back in this morning. He's currently stuck on the M25 and on his way. But I've said to him that, well, you know, we're tight in times of time. Obviously, I would normally have him sitting beside me, giving the evidence. But I can obviously take a note and then take instructions on what evidence we've heard before he gets here. If you're minded to push on before he arrives, he probably is about 20 minutes away, something like that. So, you know, I obviously my preference would be to have him next to me, and that's what I would always do normally. But
of course, yes, I understand that on both sides.
Yeah, I mean, it's unfortunate just because, you know, we slipped a little bit on the timetable, so he had to go back last night, whereas he was staying before in the hotel.
Yes, yeah. And there are one or two things to deal with first, but
yeah.
Yes.
Yeah, no, we've just been discussing that, Alan. So your fears on the M25 have been realised this morning. Yeah.
Well, when we get to the start of evidence, just let me know if you're content to proceed.
I'm grateful. Thank you.
Right. Right, just an update on documents then. So we've all got the same ones. I've got a record of 5 being put in yesterday, which I've numbered through from 12 to 16. There was the draft suggested route for site visits, 4 sets of draft suggested conditions, all from the local planning authority, Councillor O'Sullivan's statement, the committee report on a site at Lydia Park, which Mr. Cottle put in, and then a series of documents from Mr. Masters, the Planning Commission report and plans relating to the brewery at Thatched House Farm, some of which I already had, but I think I've got the full set now.
So in relation to the I've got Mrs. Chowdhury here today. And it's a task that she will do, and we hope to have redacted versions for you tomorrow.
Okay, that sounds fine, Mr. Masters.
Thank you.
Inspector, would you mind just running through that list, and then so I can jot down the ID number next to each one of them?
Of course, yes. Sorry,
to the council because it's a little bit quick.
Yeah. Number 12, the draft site visit route.
Yep.
13, the four sets of draft conditions.
Yep.
14, Councillor O'Sullivan's statement from Hascombe.
Yep.
15, the committee report for the Lydia Park traveller site.
Yep.
And lastly, number 16, a suite of documents, Thatched House, committee report, planning permission, and approved plans.
Yeah. Excellent. Thank you.
So that's those. And then just a reminder on, I did refer to a number of documents I thought would be useful that arose out of the discussion we had on landscaping yesterday. And I'm sure a note's been taken, but just by way of reminder, an extract from the policies map for Waverley, so that I've got a full an understanding of the extent of both the AGLV and, as I'm sure it will be referred to in the policies map, the AONB.
Yeah.
The document that's out for consultation on altering the national landscape. And then the technical note that Mr. Dudley referred to, which updates box 5.1 in Glivio.
Yeah. And Inspector, on the second of those,
yes,
what you obviously there's a a suite of documents on the website in terms of the
What I'm interested in
consultation. So is it the boundary
it's the boundary and
report?
relate
Yeah.
that's close to the appeal site. I think there were references to a possible extension to one side
Yeah.
and not the other.
Yeah. So I know that there's a latest boundary report that went out for consultation at the end of last year.
Yes.
So we can certainly provide you with a copy. There's obviously natural beauty reports and all sorts of other ones as well, but it's the boundary report.
It's the boundary report that I'm interested in, yes.
Yeah.
And then in terms of the site visit map, just a few suggestions I'd like to make to add to that, and again, in the light of the discussion that we had yesterday.
Yeah.
Firstly, I don't think that plan it shows the locations of the photographs that Mr. Dudley took originally.
Yeah.
And then, of course, there's the extra one from higher up on Hascombe Hill. I'd like to go to that viewpoint too.
Yeah.
And then there are a number of locations that were mentioned around Lydia Park, which I'd like to see. Reference was made to the fracking site, the Thatched House Farm rural location, a solar farm, and I think for completeness, just so that I don't just want to stay on the north side of the appeal sites. I noticed from the plan that was put in, might be a bridle way, but there's a public right of way runs west to east to the south of Lydia Park. I'd like to go along that as well.
So what I will do when Mr. Dudley arrives, I'll ask him to draw up another draft, taking those suggestions into account, and then circulate.
I think those are the main things that I wanted to raise.
I also
Mr. Cotton, please
suggest that you do turn out of Lydia Park right towards the aerodrome.
You went down Stovolds Hill.
That's right.
Yes, well, I was going to pick that up anyway, Mr. Cotton, because going along that bridleway I just mentioned that comes out on exits onto Stovolds Hill, and obviously returning then up Stovolds Hill would give me the chance to get to the access and look back to the right.
I must have missed the position of the bridleway then.
Yeah, it runs across from the road that I think we were talking about yesterday.
Right.
And ends up on Stovolds Hill.
If you motorsport, remember the old BBC program, Jeremy Clarkson.
Yeah, I know it's at the aerodrome.
It was all filmed at the aerodrome.
I know. But okay. Mr. Cottle, is there anything you'd like to raise this morning?
Only that I've invited my learned friend to agree to, is it Mr. Smythe? This is correct pronunciation. Mr. Smythe to have a word with our flooding expert in relation to possible flooding condition.
Yes, I think that's been mentioned a couple of times. Yes.
And I would just like that to take place as soon as Mr. Smythe arrives in order to save inquiry time.
And just for completeness, Inspector, so you know, I have told my learned friend that Mr. Smythe, because there was no chance that he would get on this morning, he's not here this morning.
Yes.
But as soon as he arrives, obviously, assuming Mr. Quigg is here, then they can of course chat. That's not a matter.
Of course, yes.
The inquiry.
That can happen outside the inquiry. Yes, and it's already been mentioned, so I expected that to take place. Mr. Masters, is there anything you need to raise this morning? Okay. Mr. Lintodd?
No, not from us, Inspector.
Right, and I think I've just got then one outstanding matter which I want to check at this stage. Mr. Masters, I'm coming back to you. You raised the possibility right at the end yesterday of an additional witness. Have you any further thoughts on that?
I'm not planning to make an application at this stage, so I've got Mr. Quigg here, seeing the commission.
Yes, he's been mentioned before in relation to conditions, and that's of course absolutely fine. But I said,
there is a drainage session
Of course, yes, it's on the agenda, on the timetable.
And I had in mind substituting the script for Mr. Woods and not to give any new evidence, but merely to deal with the evidence he's already given. You can see what this needs to be all through that evidence.
Well, let me check. I've got the. I think there are two flood risk assessments.
There are. There's one from Blue, which is Quiggs.
And that, I think, relates to Appeal A.
Yes.
I don't think Mr. Quiggs relates to B, C and D.
But generally, it covers the same issues in relation to general issues.
It relates to Appeal A.
If you don't object, then I'd rather when it seems to be sensible for him to participate in our exercise.
So you are asking for an extra witness?
I'm raising, if you're on the caveat.
I haven't got a proof from Mr. Quigg. I've only got his flood risk assessment.
Yeah.
And I see no benefit in him appearing just to refer to a document that we've already got in written form. I anticipate if you want him to appear in chief, it would extend beyond the flood risk assessment, and I want a proof for that. That's going to be the case.
There is another way of having a round table.
No, we're not changing at this late hour the format of the inquiry, Mr. Masters. It's all been agreed. There's been ample opportunity for discussion on that.
I understand.
Yeah.
I'm not trying to delay things or put things in that causes prohibitive. So I want to explore it.
Yes.
To see what we could do. But if that was any suggestion. If you're not with me.
I'm not with you at all on that. Okay, good. Right, well, we'll leave things as they are. That's helpful. Which means then that it's appellant's evidence on landscaping. I think, am I right in thinking it was Ms. Cottle, you're calling witness first on this? Just remind.
That's right. I was going to call Mr. Woods.
Yes.
Mr. Woods, you can just sit there, or is it going to stay where it is?
That's fine. Go on. Do you want to set? Do you want to set up, Mr. Woods? Do you want to set up in the middle? Yeah.
I think Mr. Woods was relieved to get out in the middle of 383.
Mr. Linsott, you've got still without Mr. Dudley, aren't we? We've got to.
Yes, I can feel him coming closer, but
yeah,
he's not here just yet. I mean, he
20
said,
minutes delay. So
yeah, I think if my maths were right, I would be expecting him in the next 10 minutes. So by 25 past. But you know, that does depend on traffic conditions. So I wouldn't want us to be sort of hanging on.
I'm against it going until half past because I would be asking about it plus 9.
I'm always very reluctant to delay the inquiry, particularly where we're quite tight on time.
yes.
And obviously, I'm going to try and keep my cross-examination to a minimum so that we can just push on. So I think if I'm in any difficulties, I'll let you know.
Yes.
But I think probably if I knew that Mr. Dudley would definitely be here in 10 minutes, then I might say, well, let's wait. But given
it's a bit of an unknown factor, isn't it, this morning?
Yeah, it is a little bit with the traffic and the rain and things. So I think.
Am I right in thinking it's more important that you have Mr. Dudley for cross-examination?
Yeah, I think that's probably right.
If I was Mr. Dudley, I'd like you just to give me the benefit of 5 minutes or 10 minutes, because I know it must be very stressful for him.
Okay, well, seeing as we're setting up anyway, Inspector, maybe if we do take 10 minutes just so that Mr. Dudley can be here. I can see my learned friends are on board with that, so I'm very grateful for the accommodation.
That's appreciated. Yes.
Thank you.
Okay, well, we'll take 10 minutes to give Mr. Dudley the chance to be here. So.
There is a housekeeping point.
Oh, is there?
Which we could discuss for the moment. Mrs. Chalmers is just asking me about why we need to redact it. As I understand it, you're going to get an unredacted version.
Correct.
So you'll have that information
and so will the local planning authorities, that they'll be fully aware.
Purpose of the redaction is put things on the website, so we can.
All the documentation, Mr. Chowdhury, goes on the website, so because this is a public event, so that people are aware of what information is being taken into account at this inquiry. But we have to be careful about certain personal information in terms of its public availability.
So it might be that what we'll do of the medical conditions is to take the lot out.
Well, that's what I anticipated you would be doing.
Exactly. I'm really just making certain that Mr. Chowdhury knows what you want.
What I was suggesting, Inspector, if it would be possible to, rather than put the entire medical information, just list out the illnesses of the parties
I
for
don't think
the
we
public.
even need to do that, Mr. Chowdhury. We can ignore the medical. We can just take out medical stuff and leave things in that are not medical. But
I mean, when we get to the stage in the inquiry when the appellants themselves are giving evidence, this will depend on the discussion with the advocates. If they want to make some brief reference that they're content with, well, that's up to them at this stage. But we don't want the detailed documentation about appointments and conditions and so on.
And
Okay.
thank you, sir.
Right. We'll take 10 minutes and inquiry is adjourned. Let's say till 10:30. We resume then.
Thank you very much.
I was just thinking, but it's only a mutual, it's a specific one.
It is past. Mr. Clinton, can
Yeah.
you give us an update? I heard
Yeah,
you on
well,
the phone just now.
No, that's right. I was speaking to him just now. My fears are realised in that it's an inexact science, isn't it? Predicting
Yes.
exactly when you're going to arrive. So I suspect he will be here soon, and I think probably in 15 minutes. But I think what we should do is push on, and then, as I say, 15 minutes isn't very long in the context of evidence for me to update Mr. Dudley if there's anything significant. I don't think we should just keep waiting. Because otherwise it's a how long's a piece of string, and there may be some other problem. So, but thank you very much for the time.
You're sure you're content?
I'm
with that
content to
approach?
continue. Yeah.
In that case, well, Mr. Woods is there. He's looking at the side of the room. And just to recap, Mr. Cotler, my understanding of what we've agreed is because Mr. Woods is presenting evidence on behalf of, in relation to the cases put by both yourself and Mr. Masters, you're dealing with obviously the site-specific matters in relation to Site B, but also the general points that Mr. Woods makes that cover both the sites.
Indeed.
Yeah.
So, Mr. Woods, if you could just introduce yourself, please, to the inquiry, bearing in mind it's live streamed and there are a number of third parties who are watching, and perhaps I could take you to paragraph 1.2 of your proof, that you previously worked for various different local authorities, culminating as head of development control for one of them, and you were subsequently employed at planning manager commercial property developments Crest Nicholson, and then at a different firm, and then you established your own firm in 1992, of which you're now the managing director. And 1.4, you explain the broad experience that you've had in presenting evidence at inquiries and papers at seminars and in relation to carrying out studies for local authorities relating to gypsy site provision and showman sites, and attended examinations in public. And you confirm your responsibilities in giving the evidence to this inspector. And if I could take you, please, forward in your proof to 9.2 to 9.8. I've got several questions for you today, and I'm not sure that my learned friend is going to object to me leading on this, but what you've done in 9.2 and 9.8, if the inspector's got it there, is you focused on the terms of AHN4, and then you referred to the fact that the fact of the presence of caravans is an acceptable feature of a rural landscape. And then you've concluded that there's no conflict with AHN4. Is that that's how you've approached it? And I want to ask you some further questions, if I may. And the first further question is this: we've seen the previous inspector's decisions regarding Lydia Park.
Yes.
And would they be on lower ground or on higher ground?
They will be on higher ground because they're the other side of the access track, the southern side of the access track.
And what is this inspector to make of their conclusion that there was no meaningful relationship with A, O, and B?
Well,
are they wrong, or is it distinguishable?
So, Inspector, I don't want to interrupt so short into the examination in chief, but my learned friend has asked us to turn up paragraphs 9.2 to 9.8, and you will have read that, as have I. That is a summary of Mr. Wood's case and how he argues it and puts it. I will object if my learned friend seeks to put in evidence now, which should have been put in as part of the proof of evidence, on issues like whether the site is a value landscape, to seek his judgment on those issues, on specific views and things that could have been identified in the evidence and submitted as part of a rebuttal statement, which was specifically dealt with by Mr. Dudley, or other landscape and visual matters. I've noted that he's taken us to 1.2. I've noted that Mr. Woods is a very experienced expert planning witness. I note that 1.4 doesn't say anything about landscape matters, and I expect the examination in chief to be focused on the matters that are within the proof. Obviously, those matters can be elaborated on, but introducing new evidence without proof of evidence at this stage is just simply not appropriate.
Well, I would
Mr.
just
Mr.
like-
Masters, this
I-
is
I
for
would-
Mr. Cockley.
I would just like to pick up on what Mr. Dudley was saying, which is that those inspectors didn't have the benefit of a landscape architect and the consultant, and his view was that they were misinformed. What's your view about this? Were they wrong, or
No,
were they
they weren't wrong.
distinguishable?
No, they weren't wrong. You've seen in various evidence that's been put in by the local planning authority viewpoints towards the appeal sites and beyond to the remainder of Lydia Park, because when you're standing in those locations, you're looking across, and of course you see caravans, but they were the caravans that were previously permitted by previous inspectors, and they didn't consider the impact on the then area of outstanding natural beauty, which was a field away, of such to warrant a dismissal of the appeal and say that it had an inherent impact.
My second additional question, first one was in relation to the previous inspector's decisions. The second additional question is there a difference between the sites? And I wanted to refer you to pages 44 and 45 of Mr. Ward's proof, because what he does there, sir, is he brings together Ian Dudley's proofs for all of the appeals and very neatly has the appraisal for all the appeal sites in one place. And it's a very convenient place to look at pages 44 and 45 in Mr. Ward's proof. Paragraph 429.
Okay, yes, yes.
So the point really is that the landscape effects for appeals A, B, C, and D, how do you read the local authority's case in this respect?
Well, it seems from reading this that effectively they're saying all the impacts of all the sites are more or less the same. Some very slight difference on site A, and I think from hearing the evidence, what that comes down to is winter views of site A, and that was the point. But you would see that in relation to the existing Lydia Park and the caravans that are there already.
Are there any real differences in your view between the sites?
Yes, there are. Yeah.
What are they?
Yeah. Well, that site A, has a lesser impact. A lesser impact, sir. And going along, the further you go along, the closer you get to the entrance, then there will be a greater impact.
Towards the road?
Yes.
Impact on what, Mr. Woods?
Impact on wider views, the character and appearance of the areas, which would include the area of great landscape value. I won't rehearse going through that because it's a policy matter, and the national landscape, which is beyond Stovolds Road.
So as you go work your way from west to east, the impact increases. Is that? I think that's what you said. Oh,
Yes, sir. That's correct.
Because in our opening, we've always made it clear that the inspector might dispose of the appeals differently. He could dismiss, or he could grant temporary, or he could grant permanent according to his appraisal of harm.
Exactly right. And you'll obviously be hearing the personal circumstances of the various appellants. Yes. And so that goes to the personal circumstances point. In terms of any temporary planning permission, that goes to the point of whether you consider matters will be resolved in terms of need within a period of time, or other matters related to any potential granting conditions, given the period of time for that to be initiated, or in the highest case, granting a permanent permission for the use of one or more than one of the sites. I think there's grades of. They are all separate appeals. Yeah. And to be fair, we did say to the planning inspector we wanted them all heard separately. And we were put into this position where we are dealing with several appeals, different sites at the same inquiry. And we never thought that was the right approach. It makes it more difficult for you, sir, in my opinion.
But we'll press on. The next question that I've got, which is the next question, is can Mr. Simon Doherty, is not Simon Christopher Doherty, by the way, sir, because you were asking about Simon Christopher Doherty under Weeping Willows in a questionnaire. It's Mr. Doherty, my client, is not the same person. But would Mr. Simon Doherty's
Yes.
site, can that be successfully landscaped, given what Mr. Dudley has said about the difficulty of the terrain?
Yes, I don't see any impediment to doing that. I think there's reference to the hard surfacing going across the site and going towards the boundaries and the problems that will cause. Well, it's not a serious problem to the appellant. I've had discussions with him about this. And he said, well, it's not a problem. We can clear that out, put new soil in that area where we're proposing planting, which will be subject to a site development scheme in any event, and hedgerows can go in there. And I've often appeared at inquiries where doubt has been put on the ability of the hedgerow. Oh, it's going to take 10 years to grow. It don't take 10 years to grow. You can establish a very good hedgerow within 4 to 5 years.
What sort of implementation or program or landscape condition in terms of implementation and maintenance or irrigation or whatever would be required here?
But there will be a condition requiring the scheme to be properly submitted in the first instance, in details of the scheme, the type of hedgerow, what is going to be planted. I would envisage a double staggered row. It's the normal way for doing such matters. And then as part of that condition, there will be a maintenance requirement. So if any of the planting dies, that it's replaced. And clearly that's an incentive for the appellant to make sure that the hedgerow is watered. And probably they'd have a trickle pipe going around the outside to make their job easier for them. That's what you've generally seen.
Mr. Dudley has said that when he was at Bangor University, he was studying forestry and took up a position as a result of that. He's better qualified than you to speak about the chances of landscaping being successful. What do you say to the inspector? Can the inspector, on the evidence that he's heard, decide that there's more likely than not that the landscaping can succeed?
No, he's attacking on the point. Well, I think he would always say that on any landscaping. Well, that's crazy, because you see lots of schemes, whether they be for Egyptian travellers or the settled population, where landscaping goes in and it's very successful. And so there's no reason to doubt why it should go in. And it's an odd thing for him to suggest that it won't work. I don't think he said never, but highly improbable. I think it was
difficult.
Difficult.
If it succeeded, would it be consistent with the local landscape? Because that was another point that Mr. Dudley was saying.
Yes, yeah. Well, hedgerows are part of the local landscape. So why would a hedgerow, and what we're talking about on some Dicey side is a hedgerow around the site, and you'd see it from a distance, you see hedgerows. So that's part of the character and appearance of the area. It's hedgerows. Nothing unusual about it.
And looking at the field as you come into Lydia Park, when you first see the appeal site, it would be on your right.
Yes.
Would it be out of place to see the hedging from that viewpoint?
No, it just looks like a hedge that's dividing a field.
And would the hedging be discernible from other views?
No, well, you'd see from Dunsfold Road. That's the closest
But would
view
that
from
be a
outside.
mismatch? Would that be out of joint with the rest of out of grain? I think was the expression used.
Well, no, I mean, in the countryside, hedgerows are part of the character and appearance. And in fact, there's government grants for planting hedgerows, encouraging people to plant hedgerows. So why would you not want to see a new hedgerow there? It's not.
I've got
not logical.
A more difficult question now. Is it can the stream corridor be reinstated without a gramping condition if Mr. Doherty doesn't own, well, Thomas and Simon don't own the land between them. We may find out that they do, but what's the inspector to make of this reinstatement? Because we saw a very clear figure 1 and figure 3 in Mr. Dudley's proof, which is an aerial photograph showing trees and a watercourse. And the point is, could the stream corridor be reinstated?
Well, my understanding from the appellants is yes, it could. And so a gramping condition, it's down to the appellants to make sure that it works. If it doesn't work, they haven't got a planning permission. So it's in their gift to do that, and that's what they have said that can be undertaken, wouldn't be problematic to them.
Is it reasonable for the inspector to take what the appellants are telling him?
Yes, without any contrary evidence.
A condition that
it's perfectly in order.
That the planning permission would then lapse if they didn't do it?
Of course, that's right.
But what evidence have I got, Mr. Woods? That you're just saying that they can do it. Nothing to indicate that there's any control over that land.
Well, they have. I'm not putting anything else that you need to. I think they need to be asked that question, sir, when they give their evidence. But that's what they told me, that they have the ability to do that along that stretch. So not just in front of their plots, but for the whole of the course of that access track.
I'll have to double check, but my recollection is that on the location plans, the only edging is red. The only edging on the location plans is red. There's nothing to indicate that there's any additional land under the control.
No, that's quite correct, sir.
Yeah.
That's what the plans show.
Yes.
And, when as consultants we're told matters at the time of submit the planning application, that's what we do. So we've done that. So it is what it is in that respect. But if someone saying, well, actually, I've got the ability to do that, to maintain that ditch or reinstate that ditch along there, then I see no reason why a gramping condition could not be imposed to do that, sir.
Can I move on to a different topic, please? For the purposes of AHN4, the decision maker is required to identify the area and then ask themselves whether or not the proposed development would have an unacceptable impact on it. And yes. You heard the inspector saying this morning that he'd like to visit various places, including the brewery and the site of the fracking site and the solar panel site. What is the area, and does it include the aerodrome? Because that's actually outside of the AGLV, but it's quite close to the appeal site. What's the area for the purposes of AHN4?
Well, it is all around the appeal site from all those locations. And I think that's what the inspector suggested this morning about visiting those other locations. Then I think that's good. Well, and makes sense, but also the aerodrome.
Mr. Dudley, I think in cross-examination from our learned friend, agreed that he hadn't included the brewery or the effect of the buildings there on the area. Is it right for this inspector to look at the radius of a distance?
Mr. Costle, I'm not quite sure that's right in terms of what Mr. Dudley said. I think he said he hadn't taken it into account in his baseline, but he did take us to places in his documentation where he'd made reference to it.
I stand corrected.
And he also said that he'd taken into account the buildings but he had taken them as being part and parcel of the agricultural use. And that's an
I
important
stand corrected
distinction.
because he didn't refer to the brewery, but he did refer to Thatched House Farm.
Yeah.
That's right. I accept that. Apologise. But in terms of the area for the purposes of AHN4, is it an area that's capable of accommodating change?
Oh, in my opinion, most definitely. And that was the opinion of previous inspectors relating to the same area. And the council, because they've recently granted planning permission as well. So,
So before we get to the views, would there be an impact on the landscape character of the wider area if this proposed development is allowed?
well, any development will cause an impact, but in my opinion, the impact of the development, taking into account what is already there, will be minimal.
And does the inspector have to accept the evidence from Mr. Dudley because he's qualified and you're not on this regard?
No, no, it is for the decision maker, in this case, the inspector. That's for the inspector to come to his own conclusion. And in doing that, the correct approach is for the inspector not just to look at the photographs that we had in the evidence, but to look at it in terms of the site and see from various points what you will actually be able to see, and can you discern from what has been permitted to what is being proposed. And it's looking across and seeing that, and I don't think there's any discernible difference between the two.
And looking as proposed means once conditioned.
Yes, it's not just how it is now, but how it would be with suitable conditions. Yeah.
And the local residents complain about the spread of the site from the aerial photographs. Is anybody looking at the site from an aerial point of view? Is that the right approach, to look at it from an aerial point of view?
No, I mean, it's really what you see on the ground from various vantage points, and from walking and traversing in a vehicle, what you would see, not from an aircraft or a helicopter.
And can the field which the appeal site forms part of be seen from the south?
Not from the south, no.
And it can be seen from Dunsfold Road.
Yes,
So it's having an impact on the field that it's a part of.
exactly right.
Mr. Woods, I just want to check the scope of your answers. Are you answering specifically in relation to one site or more?
Well, I'm answering specifically relating to Simon Doherty's site. Yeah, I mean that, because yes, yeah. I thought I wasn't supposed to be doing that, so I'm in a difficult position because I've got, I could talk about the community of impact if you want me to. So. Oh, I see. Yes. It relates to site B, yes, but it's difficult to ignore the other sites because they are here for your decision making. But I will be talking on one of them, but not on the other. Yeah, but if I was asked the question,
Can we just talk about the importance of the field? What's your views on this? Because it's regarded by Mr. Dudley in an important way. Are the views from the caravan dwellers a relevant planning consideration? Because they'd be looking out onto Hascombe Hill.
Well, yes, they're on higher ground and they will be looking towards Haskins Hill, yeah.
So their
So
views.
that won't be affected, will it?
But their views are affected because the appeal site would be between them and Hascombe Hill.
Oh, I see. Well, to a minor degree, yes.
What weight does the inspector give
Limited
private
weight.
views?
Very limited weight for private views. It's really, you know, what should be the critical analysis relates to public views. You know, you're not entitled to a view as an individual.
So again, in relation to the field, can it? I think we've probably covered the point. It can be seen from Dunsfold Road.
Yes.
And I think the question that was in the air just beforehand is whether your answer about being able to see the appeal site is different for Appeal A than Appeal B or Appeal C or Appeal D.
Can you not talk, please? All I'm getting is a buzz. And sorry, could you?
We've been asked about the importance of the field. And one of the questions that I asked you was where it could be seen from, and we're going to go through the views in a moment because that's going to be about our last question for you. But in relation to Appeal A, is there a distinction between views from Dunsfold Road in between Appeal A and, for example, Appeal C and D from Dunsfold Road?
Well, yes. Appeal A has got some existing planting that is there, and you've heard from Mr. Dudley's evidence that the problem he perceives the problem as being the winter months. So the views are further away from there. So Appeal B is closer to Dunsfold Road, but it should not be judged on what you see at the moment. It should be judged on if planning permission was granted, if the inspector was minded to allow the appeal with the appropriate landscaping that could go in.
Now, one of the issues that we're going to take up in the planning balance is policy. So I'm not going to ask you about whether breach of RE3 means breach of AHN4, but just supposing that we're looking only at AHN4, would the impact of Site B on that field be acceptable or unacceptable?
Acceptable.
Now, can we just go through the views, please? And I'd like to begin with the supplemental proof of evidence of Mr. Dudley.
Okay. Is this CD 10B1?
I've got it down as CD12, but I may be wrong about that. It's a supplementary landscape and visual proof of evidence, and it's got the views that were taken by the other officer, Mr. John Bennett. It's the most recent statement from them, from the local planning authority. 13th of May, it's dated.
Mr. Woods, the reference number I've got from the website is CD 10A little 1.
Thank you, sir.
Just while the witnesses,
CD 9B to CD 10B.
10A, and then it's a little Roman 1, I think.
Yes, that's
10A,
right.
little Roman 1.1.
We've probably got it in the corner.
Inspector, just while the witness is finding that document, I've been taking a note of the particular questions and answers and relating them back into the evidence that's been provided. So I haven't objected to questions which have related back in whatever form to the evidence that's been provided by Mr. Woods in writing. But I obviously make the point that there was an opportunity to respond to particular written evidence by way of rebuttals or supplementals. That wasn't done. So I would ask you to bear in mind in terms of evidence given in respect of, I don't know what's going to be said in respect of supplementary evidence that Mr. Dudley has provided, but it's just not appropriate to provide new evidence at this stage without having disclosed it before.
You know our response, which is that the views from Stovolds Hill were always obtainable from day one, and it came in on the 13th of May. And that's why it's been dealt with in this way. It could have come in with the appeal statement of case. I apologise if it's placing my learned friend in any difficulty, but we're just going to go through the views, which you must do, in order to have Mr. Woods of the appellant's side comments on those.
Well, I do want to hear the appellant's views on it, but there was a reason for it being in the supplementary evidence, and that was because of the ability to see those views, as Mr. Dudley explained, and there was an opportunity for a response to the supplementary evidence as well.
Well, I think the point remains that the winter views were obtainable since 2022 when the planning application went in, and it's 3 years later that they're supplied.
And on that point, Inspector, there is no commentary on any of the views that were put forward either in the main proof of evidence or discussed in the rebuttal either. So the same point can be made in respect of supplemental evidence, any rebuttal evidence or the original evidence. There isn't any commentary on any of those views. So that's the issue.
Mr. Masters, I've already said I want to hear what Mr. Woods has to say. The point is, the efforts were made to organise things. There's no specific provision for rebuttals in the rules. So I wanted to make clear that that was how I would prefer to have the matters dealt with. And the opportunity wasn't taken.
They have to do, therefore they have to rely on witness to be able to make any comments on it.
I regret being in the position that we're in, but I hope just to proceed now.
And Inspector, I haven't, just to be clear, I haven't objected. The way I put it was very careful, which is that there's been opportunity to put the evidence and views. Obviously, if it's something which doesn't cause any prejudice, then it's important that you have everything in front of you. But the point of putting in at least a summary of what you're going to say in advance is so that when the local authorities witness gives evidence, he's able to have that evidence in the light of the written evidence as to what the other side's case is. It's simply not appropriate after the witness has been called to introduce new factors that he couldn't have been aware of because that wasn't in the written evidence. Now, obviously, Mr. Cottle is an extremely experienced advocate. I'll see what he says and whether there is that prejudice, but I think it's only right, given the extremely limited amount of information at 9.2 to 8, to make that point at this stage, and so that you've got it in mind, Inspector.
Well, I hope my questions are only reflecting the line of cross-examination I took with Mr. Dudley, which is that the effect of the proposed development will not have a discernible impact on these views. Mr. Woods, is what effect would the proposed development have on the view that we see at just under paragraph 16 on page 2, I believe?
Yes, I've got that. Well, I don't think any discernible impact whatsoever.
And then we've got another two on the next page. Not clear because we haven't got it marked, I don't think. Maybe we do have it marked as to where these photographs were taken from. But they're a fair distance away.
They are, and I can't see
Mr.
how.
Cottle, I think that was leading.
Right. Can we just have your views on these photographs, please, Mr. Woods?
As I was about to say, the looking across there, if you were a walker walking along there and you pause to have a sip of water and look across, I can't see how you find any discernible difference in the landscape from the, if the appeal was allowed. Because you've got to bear in mind that the development that's subject to the appeal is on the site, so it is there, and there's been no attempt to identify where on that horizon these particular caravans are.
And looking at the photograph underneath paragraph 23.
Okay.
And if you sort of increase the...
Yeah, you're looking across there.
If you increase it to sort of like 300% or 200%, you can see behind Lydia Park.
Yep.
And are those views a reason for dismissing the appeal or not?
I'm just trying to fit it all in the. No. You know, and this also it's a winter view, so I think in the summer you wouldn't see it. Full stop.
And if we could turn now to the proof of Mr. Dudley, please, and it's the view that we find underneath paragraph 511 on page 29 of Mr. Dudley's proof, figure 8, the view towards the site from the public footpath.
If I could, can you give me a CD document number?
The one for site B is CD 8B.2.
It's on page 29 and it's figure 8, and it was the first, or one of the first questions I was asking Mr. Dudley about. I was asking him, is this it? Is this the high point of the local planning authority's case?
So CD 10B.
It's Mr. Dudley's proof.
8B. Thank you very much, sir. Thank you.
It is 8B.
Yeah. Okay. So 8B2. Thank you, sir.
It's page 29 underneath paragraph 511, and it's figure 8.
Sorry, paragraph
511, figure 8, page 29.
Oh, guessing that. Figure 8, yes.
And have a good look at that. And then you see paragraph 513, what's said is that they are prominent.
Well,
What I'm interested in is the fact that this is a view from a footpath within the national landscape. So the inspector is going to be alert to the fact that this is a view that counts, because it's people who are out to experience the AONB, the national landscape, and lo and behold, the planning authority is saying you'll be able to see the proposed development. Now, just imagine for a moment the effect of vegetation. Would it alter that view? Landscaping.
yeah, but I think if you were walking along that footpath, I don't see that you see the stark contrast that it would be a serious impact. And if you've got additional planting, of course that's going to reduce any impact, or when the trees are in full leaf.
So what weight should the inspector attach to the fact that people would be able to look to the left, and they might, while the vegetation landscape is growing, be able to see the roofs of the
Very, very limited weight, in my opinion.
And is the best evidence the inspector's own site visit and appraisal, or Mr. Dudley's evidence?
It would be, best evidence would be the inspector's own site visit and appraisal. I think that's what it comes down to in terms of what you see when you're walking round and taking it from these viewpoints as to what that impact will be.
Is it reasonable for the inspector to disagree with Mr. Dudley over this?
Of course, it's most definitely.
I've got no further questions. Thank you very much, Mr. Woods. We just wait there.
Okay.
Thank you, Mr. Cottle. Mr. Masters now.
Are we going to do it like this, or are we going to cross-examination and come back?
No, you're next. You've got questions in chief, haven't you, for Mr. Woods in relation to site A?
Shall I move round?
Yeah, I think that'd be easier. And we're dealing now solely with site A.
No. We're dealing with my cross-examination with Stovolds about all the aspects on which I asked him questions.
No. No, we've already agreed how it's going to be dealt with, Mr. Masters.
What happened during this inquiry? My learned friend objected and then didn't pursue the matter. But I'm going to ask Mr. Woods, unless you will against me, about some of Mr. Dudley's answers to questions that I've made. So you have a complete picture of what we're saying, and not just Mr. Dudley replies. And that has to be right, because you've heard what Mr. Dudley said, and I'm going to go straight for it.
No, I'm going to be absolutely clear on this, Mr. Masters. It's been agreed how we would deal with this. Mr. Woods is not been examined in chief twice on general matters.
No, he's not examined even once on this, because when, let's just take the first thing.
That was a matter for you and Mr. Cottle to organise, and you told me that you.
Yeah.
Yes.
What happened, to understand, is that Mr. Cottle tried to put questions on the baseline, which were rejected on the basis, well, there's no baseline evidence, Mr. Woods' evidence. So Mr. Cottle didn't proceed. And I'm going to proceed unless you rule against me. It's a matter for you. It hasn't been done yet. But I must be entitled to ask Mr. Woods to comment on the evidence given about baseline by Mr. Dudley. And those questions weren't put by Mr. Cottle. So there's no repetition. But they were put. I will be asking this. And I must be entitled to do that. So you understand his comments on what Mr. Dudley's evidence were. And And so I'd say that that's a basic fundamental principle of Article 6, and if you disallow it, in breach of natural justice. If you allow it for you, you can do it, I won't proceed with that, but I think you should allow me to proceed.
Mr. Lenzel, do you want
I
to?
obviously object to that. You made it quite clear that as a procedural matter in terms of how the inquiry needed to progress and get through within the timetable that you've allocated, that we needed to approach it in a certain way. Now, that means dividing up the evidence in the way that you indicated, and that means that the advocate's deciding who's going to lead on various topics. It's simply not appropriate because one advocate is not happy with the way the other advocate has dealt with matters to say, well, I'm going to deal with that topic now. What you said was that it would be matters relating specifically to Mr. Masters' case, and you particularly drew attention to paragraph 9.8 of the proof of evidence and said that you were going to look very carefully at what questions were asked. And so you're absolutely within your rights to deal with things in that way, to procedurally manage the inquiry, and I urge you to do so.
Mr. Cottle wasn't excluded in asking questions of Mr. Woods, though. I said I was quite happy to hear the position of Mr. Woods.
And so then no questions are asked about baseline. You haven't got any evidence about baseline Woods yet. And I wish to do that, particularly bearing in mind that Mr. Dudley explored baseline in far greater detail than Debbie put in his evidence, because we went to issues about the brewery site.
Because of the questions that were asked. Yes.
So I think if you don't hear Mr. Wood's comments, there's been a fundamental breach of natural justice. And I can also reckon, although if I'm objecting to Mr. Wood's dealing with this in Mr. Cottle's brief, and now objects to me doing it. So when we get to the court at some future date, they'll have a record that was his attitude.
We're quite satisfied we've got enough evidence here to win without going to High Court, because there is sufficient basis for you to allow these appeals. But I
It's part of my duty to get these things on record. So
Mr. Masters, one of the problems with the inquiry is that arrangements were made to try and organise things in an efficient way, and it's not helpful to keep having late suggested alterations to how things are to be done. Mr. Masters, you've had the opportunity to organise things with Mr. Cottle. It was made. Mr. Cottle confirmed at the beginning of this week that he would be leading on general points, and you've had the opportunity to discuss these. And you could.
Point wasn't taken, and so I must be allowed to take points that haven't been taken, would otherwise be fundamentally cause.
I am ruling against you on this, Mr. Masters. The initial position, you asked for flexibility, and I said yes, there will be flexibility in terms of site A, and the sites are different. There may well be different points in relation to landscape, and you're entitled to ask about those.
So I've been very flexible in not pursuing matters because of things you said, and I've agreed with every ruling you've made so far. Fundamentally disagree with this one, because this is a topic that hasn't been ventured yet. It's no use to say that, okay, there was a chance of it being ventured. I represent someone different, okay? Mr. Cottle, for whatever reason, when the objection was made, my learned friend didn't pursue it. I think he was wrong not to pursue it, and I think I should be allowed to. And I think you will be wrong by not allowing me to do it. But it's a matter for you, and I don't think there's going to be any prejudice to my learned friend whatsoever, but there'll be fundamental prejudice to me.
And Inspector, you've made your ruling, but just for completeness, in respect of the factual matter of what was put and whether Mr. Cottle was actually prevented from putting anything. The discussion about baseline was simply a correction by you and me as to what had been said in respect of that by Mr. Dudley. It was during the part of the examination where Mr. Cottle was talking about AHN4, and before he went on to say, would there be an impact? So it was in between his questions 6 and 7. And in my view, you rightly reminded him of what had been said, and he accepted that. There certainly was, in my note, no indication that Mr. Cottle didn't put anything as a result of anything that you or I said.
So this is contrived.
That's just my note.
This is contrived, sir. That's not correct. Disagree with that entirely. First of all, and more fundamentally, I put those questions to Mr. Dudley in cross-examination about baseline, not Mr. Cottle. Okay, when we made the division, you didn't object then. Okay, so you allowed me to do that because fundamentally I was entitled to, and I made the point at that point in time. I won't cover anything Mr. Cottle doesn't cover, but he didn't cover that, and so I must be allowed, having put that to Mr. Dudley, now to pursue the same situation with Mr. Cox. Fundamentally, if you're not allowing me to do that, but then what was the point of allowing me to ask Mr. Dudley those things in the first place? Which you did and didn't object, and no objection from my learned friend. The horse has bolted by allowing me to do it then. And if I can't do it now, then I'm afraid there is a fundamental error here. So it's with regret, I've got to say, but I do take it as a fundamental error. And I think there is absolutely no prejudice to my learned friend whatsoever. It's all about timetabling. Well, we're doing okay on timetabling, but if we have to have another day, and that's going to incur an extra cost, well, you can blame me and my clients will pay the costs. But you shouldn't prejudice my clients from presenting their case because of timetabling difficulties, because that would be fundamentally wrong as well. So I am insisting, sir, please, that you allow me to ask him questions on the baseline. And I don't see that that could be fundamentally wrong at all and cause anybody prejudice. Certainly, my friend's not even arguing on prejudice. He's arguing on the technicalities of your rulings.
Mr. Linton,
Yeah, well, I mean, as I read it, you've made your ruling. You've already said that you ruled against Mr. Masters. My correction was simply in respect of, in fairness to Mr. Cottle, what the exchange was and what my note of it was. I don't suggest that my handwritten note is absolutely accurate. You'll have your note of what was said and what questions Mr. Cottle put, but that was the reason for it. And I have nothing to add in respect of your ruling that that topic shouldn't be pursued. There is obviously a difference between challenging a witness, quite rightly, as Mr. Masters was entitled to do, in respect of the evidence that had been put in by Mr. Dudley that was in his evidence, and that's capable of being challenged. It's another matter, of course, to lead evidence from your own witness that hasn't been put in before. That's the difference.
I'm not planning to lead any new evidence, sir. So perhaps my own friend's misunderstanding. I want to ask my witness about Mr. Dudley's evidence, which is already before you, and get his comments on that. Not planning to put in any new evidence about baseline, but merely to ask Mr. Woods about the evidence he heard from Mr. Dudley on baseline.
I don't know if it's any support for Mr. Masters, but my questions were geared to AHN4. What is the area? And what are the things that you're looking at in the area? And I was criticised because I was taking Mr. Rowe's point that the buildings on the brewery were a material part of the area. And so I wasn't looking at the baseline of the particular appeal site. I was looking at the area for the purposes of AHN4. Those were my questions.
And so I was the person who, when we split things up, who dealt with baseline. And also I was the person that dealt with one or two other issues. And no objections was taken with how we split it up then. And I didn't anticipate, because we'd done it that way, but objections would be taken in examination in chief of my own witness on the same topics.
Can you start, Mr. Masters, with questions about appeal site A, please?
Yeah. So you don't want me to go on the baseline, sir?
But, start with your questions.
Well, I will start with my questions. So, Mr. Dudley, when we were dealing with the general sites, you may remember I referred to the baseline.
Inspector, that goes contrary to the ruling that you've just made, not to go
No,
to
he
that
doesn't.
topic.
Well,
The inspector
let
said
me hear
just,
the question, just see how Mr. Masters is wording it.
yeah. I wonder if you could comment on the way that Mr. Dudley dealt with what he perceived to be the baseline and whether or not you agree with his comments.
But that does go against what's.
So it does. It's not introducing new evidence. It's merely asking this witness to comment whether he agrees with Mr. Dudley or not, and why, if he doesn't. And if I'm wrong,
But I want your questions to be in the context of Site A.
well, but so I didn't ask Mr. Dudley only about Site A. I asked Mr. Dudley and about the sites in general for a number of questions, and I only took him to Site A, D, and
C and D.
C and D, which is my ones, and later on, and so, sir, I
put your questions in the context of Site A.
You heard what Mr. Dudley said about the baseline in terms of Site A and C and D, because those are my other cases. Could you help us about whether you agree with the way that he dealt with the baseline?
Yes.
It's been put in the evidence relating to the brewery site, the fracking site, and the solar farm site, and the context should be, if you're going to do a landscape visual impact assessment, should be taking all those in together. So, in short, no, I don't agree with Mr. Dudley's assessment, because it doesn't appear that they have any great weight has been given to them in doing his assessment.
Thank you. Mr. Dudley said that effectively the baseline was for an agricultural field, wooden field, blah, blah, blah. Although he accepted later on that there was some element in which one could consider the caravans. Do you agree that the caravans have to be looked at in a baseline of a wooded field?
There was photographs. There was a photograph, I think, of 2022, 2023. But before our client purchased that site, there weren't trees on that site, and it was a low-grade field.
And just on that topic, because you've got there, which is at the date we look at the baseline. Do we look at the date of the baseline in a photograph of the trees being there in 2020, or at the time of the development in 2022?
Well,
Mr. Muster, I want to be clear which photograph we're referring to here. It's the one that's in Mr. Dudley's proof on Site A?
That's my understanding, sir. I mean, I'm still waiting for Mr. Cottle to put in the photo showing the trees there from the High Court action.
We were taken, I think, to Figure 1, which relates to Site A. Is that? I just want to be clear what you're referring to.
That's my understanding. And in fact, it was Mr. Woods that put the photo. Which photo are you referring to, Mr. Woods?
Oh, crikey! I haven't got it in front of me now, but there was a photograph that was produced that showed the naked field, I suppose, and
that's not Figure 1.
That naked field was like that when our client purchased the site. So
purchase Site A.
Oh, crikey, I'm getting confused now with the other one. Sorry. That's a field B.
Yes,
I do apologise, sir. Yeah,
that's not relevant to this.
I'm confusing myself. No, could you ask me that question again? Because I got in my head the photograph of the field that relates to
I don't.
field B, so it's not the same.
Well, it is the same. We looked at. And I took Mr. Dudley to the photograph of field B, didn't I, as part of my cross-examination?
Not only did you
probably
not do
but I'm
that,
not dealing
but
with
you
it.
You're not
actually
dealing
didn't
with
have
site B
Well,
at all.
in front of you.
I'm sorry, sir. As I said, I am suing this because I was allowed to put it in cross-examination, so I must be able to ask questions on his examination. At that point in time,
Mr. Masters, I'm being flexible, but it's got to be in the context of site A.
but why not C and D? I also represent those, and
Because Mr. Woods doesn't represent them. You've got Mr. Rowe you can deal with on that. You have Mr. Rowe as the planning witness in respect of sites C and D.
So I'm asking a general question about.
You can't spread general questions around all the witnesses.
No,
Mr.
but I'm
Masters.
not. I'm asking a general question about the general baseline.
Mr. Masters, there's got to be some discipline in terms of your approach to the inquiry.
I do understand that, sir, but forgive me. Sir, may I please explain this to you? When I put the baseline to Mr. Dudley, I didn't put it in the context of one individual plot. I put it into the context of the surrounding, because that's the way that he addressed it in terms of the surroundings. And so it would be entirely wrong to constrain me and Mr. Woods to an artificial plot when Mr. Dudley's put it in terms of a surrounding area rather than one area. And so when I ask questions about how Mr. Dudley's answers, they are to the surrounding area. Mr. Dudley never put it in terms of plots B or plot C and D or plots A. And so it's an artificial constraint, which I don't think is going to help anybody.
It's not a constraint at all. It's simply asking you to refer to put the points that you're concerned about.
Yeah, I know.
Having regard to site A.
Yeah.
And surely you can do that.
In regard to site A, Mr. Dudley was asked a general question about the surrounding area around site A, which included site C and D and B. And in that regard, we had a discussion about the photograph relating to site B. You may remember at that point in time that Mr. Cottle intervened because the inspector has allowed him at some point in time to find a photo that's apparently in the evidence hasn't yet been produced of the removal of the trees.
The further photograph that I was hoping to find was in relation to the rolling out of one of the developments to show that the field was empty, and it was actually echoed by the councillor yesterday, which is that the local residents would back me up on that it was only rolled out in an unpermitted way. That was the further photograph, but we do have photographs that show that the trees had gone before Appeal B purchased.
So, Mr. Woods, you were dealing with the difference between the photographs. The one that we do have showing the baseline without the tree line, and the one before showing it is. Could you continue with your answer in respect to that, please?
I mean, I really don't want to interrupt. I mean, Mr. Masters has almost had his entire time already, and sometimes interrupting doesn't save time. But this is an important point of principle that you must address, because what Mr. Woods has said very clearly is that the answer he gave before was on site B. And we can all understand that, because site B is the site which Mr. Cottle was talking about, where there was an issue as to when the trees had been removed. We've got the site A proof in front of us, page 13 of that, figures 3 and 4. We can see the trees are in place. And moreover, Mr. Woods has confirmed that he's not making that point in respect of site A. Mr. Masters isn't representing in terms of B. If you allow Mr. Masters to do this in respect of these issues, this inquiry will just never be finished. You have to have an amount of discipline in terms of the questions that are put in line with what you've already ruled.
Mr. Woods is not saying that it's not relevant. He's complying with your view, but we can't ask any questions in relation to anything but site A, which is what I'm challenging, because in fact, the baseline was put in the context a moment ago.
Mr. Masters, you really do need to move on and ask a question in the context of site A.
Well, I thought I had, and I'll try again, because I'm not going to, because you're going to have to rule against me. In relation to site A, I put to Mr. and in relation to sites C and D, for that matter, I put to Mr. Dudley questions relating to the baseline of the general area. Okay, and in terms of the general area, that was defined because the inspector intervened to ask me what I meant by the general area, and I said the immediate wooded area, where the wooded area was, and also Lydia Park. Do you remember that, Mr. Woods?
I'm sure that's what was being spoken about, because of course that's what any assessment and in terms of looking at it needs to be taken into account. And what you do in terms of appeal site A is, what do you see it in what context? So if you were seeing it from public areas, very little would you see of it. The closest being Dunsfold Road, and you see it through filtered view through trees that are there, and you see it against a backcloth of trees on the right hand side going beyond the appeal site, and to the left you see it the backcloth of Lydia Park and all the caravans that are there.
Did Mr. Dudley limit his baseline merely to plot A, or did he limit it, or did he approach it from how plot A sat within the wider area that we've described?
Well, I don't believe he did, in terms of what should be taken into consideration in terms of the brewery site, the fracking, and the solar farm. I'm excluding Dunsfold Aerodrome because although that's within the wider area, the area that's there, you won't see visibility of the appeal site A from there.
Now, I'm going to try once again then. One of the things that Mr. Dudley referred to, and he was cross-examined about, was whether or not there, at the time of the development of plot A, there was a tree screen adjacent on other plots, and that became a fundamental issue. Now, what's your position? I'll try again, about when the inspector should, what date the inspector should judge the baseline at, 2020 or 2022?
2022.
What's this in relation to, Mr. Masters?
This is in relation to the baseline, sir.
And site A?
In relation to site A for the moment, if you want. It's because that's the way that he put it, and that was a general. So you disagree with him saying that as far as he was concerned, you judged the baseline from the date of the first development of the site, because that's the way he put it.
That's the way he put it, yes. It's specifically in relation to appeal B.
That's right. He put questions about the baseline in relation to other sites and when the baseline started.
Yeah.
So he didn't view the baseline merely on the basis of plot A, did he?
No.
Thank you.
Looks at the wider area.
Exactly. So having established that he didn't address the baseline on a plot by plot basis by reference to the four plots, was he right in taking the view that he was entitled, when looking at the baseline, to ignore the fact that those substantial rows of trees we see in the photos had been removed by the time any proper development started on any of the plots?
Well, they were nothing to do with the appeal developments, so they shouldn't have been taken into consideration whether trees have been removed or not.
Okay. And do you remember Mr. Dudley on this topic said, well, I took them into account because I thought they may be intentional unauthorized development, and then we had a whole argument about whether or not there was any evidence of that. Could you comment on that evidence, please?
Just the vaguest possible question about exactly what you said not to do, and Mr. Masters is just doing it again, Inspector.
So yeah. I'm asking questions about Mr. Dudley's evidence. If I don't do that, Mr. Woods won't be able to comment, and you won't have his answer. All you'll have is Mr. Dudley's evidence. And Mr. Woods is entitled to comment on it. You must hear what he says about it. And it was given in chief, and it was given in cross-examination. It wasn't something he'd even written down.
No, but you're straying back to site B, Mr. Masters. So can you move on, please, with your next question?
So forgive me, sir. It was said by Mr. Dudley in the context of site A, because the way that he put it, his baseline was in the context of the 4 sites, not just site B. So his evidence, although it referred to site B, was in the context of the baseline.
I've got my own notes about that, and I'll refer to those in terms of what Mr. Dudley said.
But
You've already asked quite a number of questions about baseline and related that to site A. I want you to stick to that line.
I'll leave it, sir.
Right, we'll move
tried
on
my
then, please.
best. I'm grateful. Okay. So, in the context of the moment, since that's the way I put it's been put of site B, and Mr. Dudley's approach to site A, thank you, and Mr. Dudley's approach to baseline, Mr. Woods. Okay. I wonder if I could recap your answer just a moment ago.
I've got a note.
I know, but please, sir, because there's been so many interruptions, I want to understand that I've got it right. Okay. Do you agree, Mr. Dudley, that the appropriate time to analyse the baseline is 2020? Yes or no?
No, it's at the time the developments took place.
Thank you. At the time the developments took place, did the baseline in relation to plot A include the fact that the brewery site had 3 extensive developments that were nearby?
That will be part of the consideration, yeah.
Thank you. At the time of the baseline, did the fact that the planning permission existed in relation to the fracking site?
I'm not sure that it did then.
Okay.
Because that was subject to a High Court challenge, and I think it was only last year. But I think Mr. Rowe refers to that, so perhaps you ask him.
Okay, thank you. At the time of the development, did Lydia Park and the lawful developments to one side of the site exist, and did that affect, in your view, the baseline?
Yes, they did exist, and yes, it did affect the baseline. Subsequently, the council have granted planning permission for additional pitches in Lydia Park in the same area of great landscape value.
Okay. Now, I want to go on to character. Remember I asked Mr. Dudley about character. Again, he assessed character in terms of character type and then land character. Do you excluding, we say, some of the aspects we've already looked at a moment ago, the brewery site, the caravan site, and that matters. His view was that in terms of type, this was more akin to an open field. Do you accept that?
Now, in terms of character, you need to look at the character and appearance of the area as it is. And the character and appearance of the area is dominated by Lydia Park.
Thank you.
And all the caravans.
Thank you. In your view, does site A, in the context of Lydia Park and the other sites in this site, reflect the character area that's been designated, which is basically one that doesn't make any reference to caravans?
Mr. Masters, I'd be grateful if you didn't lead with your questions.
Okay. Accept that, sir. Sorry. I was just for quickness, so I could have taken Mr. Dudley's evidence where it is. Perhaps I should do that. You pick up, Mr. Dudley.
Well, I mean, the appeal side, in terms of looking at it, it relates more to the existing caravan site at Lydia Park than it does to the countryside. It's sort of intertwined with that more than anything else.
Just let me find Mr. Dudley's evidence. Thank you for that answer, but I'll just go to Mr. Dudley's evidence. Give me a second to find it. So everything else I did have it. Have you looked at the character areas Mr. Dudley identifies?
Are you talking about Mr. Dudley's original evidence?
Yes.
Right, okay.
Just trying to find it myself. Yeah, I've got my copy marked up, but thank you, Steve. So I think that's the character assessment areas rather than think. Thank you, Steve. Give me a second. Sorry, sir, I put this away because I was hoping to deal with it in a quicker way, but stand that will cause me to lead, which is not the right way to do it. Yes, I've got it flagged up. I've just got to find out what I've done with this. What's the case?
Do you want the section in Mr. Dudley's proof where he's dealing with character?
I have. I've now found it, so that I would be grateful for the section that would assist me.
But he starts to talk about the local landscape character assessment, I think, on page 16.
Thank you, sir. I'm sorry for the delay, sir. So we got the landscape baseline appraisal. And we could look at 3.3, and we're looking at the low wild. Does site A, in your view, fit in well with that? Those descriptions of an area?
No, it doesn't, no.
You see, at 3.8, he says, based upon the above analysis, the site and the setting considered to be strongly representative of a wooded low wild landscape type.
Well, I don't consider that to be the case, no.
Do you consider his appraisal based on that analysis and that finding to be one that can be sustained?
No, I don't agree.
Have any looked at wooded low wild?
Inspector, I hesitate to interrupt again, but just for your note, really, Mr. Woods hasn't put in any evidence, obviously, on the character areas and whether or not he agrees or disagrees with the bulleted list of low wheeled landscape type areas, why he disagrees with that. We had no evidence on that at all. And so for you to allow him to put in evidence in examination after Mr. Dudley has been called. There was an opportunity to put these specific points in respect of that character area to Mr. Dudley, if that had been wished to do, and to say, well, it doesn't accord with those, does it? That just wasn't done. So again, I'm conscious of the time, and I'm conscious that my interrupting might well just delay things further. But I must say on behalf of my client that it's not the correct way to go about things.
So I'm sorry, sir.
No, Mr. Masters, I understand your concern, Mr. Lintup, but these questions do relate to, specifically do relate to Site A. And as they have been raised in the local planning authority's proof on this matter, I am content for questions on this.
So again, if we look at 3.9, we see the key characteristics of wooded low-willed landscape type. Any reference there to caravans?
No, there's no reference to caravans whatsoever.
And then at 3.13, he makes a reference based on that. There's more moderately representative, he says, to that character area. What do you say to that?
Well, no, it's not. It does refer in there. So the main source of incongruity relates to the presence of the existing gypsy and traveller site to the south of the site's access track. So, yes, but that is part of the character and appearance of the area. And that's not reflected in the character assessment, but successive inspectors have allowed appeals there, and the council have allowed development there. So to say that it's incongruity is a concern as such. Something that's been granted planning permission.
I'm grateful. I'll move on because I'm going to be criticised for time. So I just wanted to, and I'm only dealing, sir, with Mr. Dudley's answers to in cross-examination. I'm not introducing anything new. I'm now going to go to valued landscapes. Do you remember that Mr. Dudley was asked questions on valued landscaped?
Yes.
And in chief, first of all, he said to answers to questions to the inspector. But the designation AGLV automatically registers this site as a valued landscape for purposes 187A of the MPPF. Do you agree with that?
No, that's the wrong approach.
It's not what he said. Specifically with Mr. Dudley in my own questions, and I have a note of the various factors that he said he took into account.
Yeah, but on the second time you asked him, sir, he made some caveats. When I asked him, and I asked him specifically on a number of occasions, he said that was enough. And I've recorded that on a number of occasions. But yes, you're right, sir, his answers changed. It changed when you asked him first, and then when you asked him secondly, it changed. But it didn't change when I kept asking him as to his approach, which is that the AGLV was enough. And I asked at him in the context of the Williams case, I think, and the way that the inspector did it there, and which he conceded was that way because that's the way he had put it to the inspector. Do you remember that, Mr. Woods?
The Willows case.
Yes.
The point is that no inspector has, in relation to Lydia Park, considered that the AGLV in this specific area is a valued landscape for the purposes of the framework.
Do you consider, based on his answers, but the inspector should find this is a valued landscape merely because it's an AGLV?
No, I don't. As a national landscape, yes, of course, then that's a valued landscape. But in terms of the local designation, and we've heard the national landscape is being reviewed, and to the west is to be likely to be included. So that's on this plan here. Over that side, to be included, but not the land that's covered by the Lydia Park and the land to the north of that. It's not a candidate for inclusion within the national landscape. So we have a local designation, we have an assessment that's carried out, and one would have thought the assessment looks at whether that should become a valued landscape for the purposes of the framework, and it's not a candidate for that.
Thank you, Mr. Woods. Mr. Woods,
Can you move on? You are encouraging Mr. Woods to go into other areas.
Mr. Woods, please don't stray into other areas. Just keep to the. Yeah, just keep.
Only answer the question.
Yeah, just keep to the answers given by Mr. Dudley. So I'm going to continue.
I want to move.
Yeah. Well, only just one. No, okay. I'll move to valued landscapes then. Views, Mr. Woods.
Sorry, views.
Views, Mr. Woods. In relation to Site A, as you've already said, Mr. Dudley took the view that there were that the surrounding short-term view of the site, and indeed of the other sites, okay, was not objectionable. His concern was about longer distance views or middle distance views. Do you remember that?
Well, his assessment came out more or less the same for all of the sites.
No, if I could just ask you to concentrate on the very specific question I put to him, which he conceded, but his concern was not about the short distance views from the road up to Stovolds Hill. Do you remember that?
From Stovolds Hill, well, you won't see the appeal side A from.
And but I specifically asked him about the views on the access road in, as to whether that was a concern for him, and he said no.
Well, no, it was quite rightly because it's a private area.
Right. So, we established that it was those semi to longer distance views that were his concern. Do you remember that?
Yeah, I do, yes.
Okay, thank you. Now, in terms of that, he said that caused significant harm. What's your view in relation to Site A?
I totally disagree. Very limited harm in terms of what you would see of appeal Site A from either Dunsfold Road or beyond, and the photographs bear that out.
Do you remember I asked him about mitigation, landscaping and mitigation?
Yes.
Okay. In that context, and bearing in mind his answer about the views, the short-term views of the site from the access road, if his view was that's an acceptable view, would you need to mitigate that by landscaping?
I don't know if that's acceptable. No.
And then, so in terms of landscaping for longer distance views, you've given some evidence to Mr. Cottle already about that, haven't you?
I have. In terms of appeal Site A, it could benefit from some additional planting on the southern boundary, but views into the site accepted by Mr. Dudley are really only going to be in the winter months, and then it's from a distance, and the views are filtered by the branches of the trees.
From the views that he took from his photo viewpoints, can you distinguish Site A from any of the other sites?
I think it's very difficult to distinguish Site A from the general caravan park that is there.
Well, that's what I was going to ask you. Can you distinguish it from Lydia Park?
I've just said, not really.
Yeah, okay. And would you, in long distance views, see the site in the context always of Lydia Park?
Yes, you would.
So in your view, does it, is it significant harm in addition to the visual harm caused by Lydia Park, which is lawful?
No.
We need to be clear about the scope of that question, Mr. Masters, because what you see at Lydia Park, bearing in mind the evidence that's been put so far, I don't think is lawful. It's the use that's lawful.
That's very true, sir. I accept that. Well, but bearing in mind you've said that, I'm going to ask Mr. Woods about that. It is true, isn't it, that there's a greater intensity of caravans on Lydia Park than should be there.
Yes, most definitely.
Would you take the view that in terms of long distance views, that would be readily definable and would add to harm?
Well, your eye is drawn to that, and that makes the situation worse. But that's not the appellant's fault in this case. But you would still see it as a caravan park, whether it's a lesser number or not.
And assuming that the numbers were lawful, as opposed to what is there now, do you agree or disagree with Mr. Dudley's answer that the additional caravans cause significant harm?
I disagree. I don't consider that it would cause significant harm, no.
And in terms of, do you remember Mr. Dudley talked about soil damage? Not sure he made that reference in relation to Site A or not. I think he did, but I'm not sure. Yes, he did. Actually, irremediable. What's your comment on that?
Of course, it's remediable. There's no reason. You know, soil can be improved, and you can move away hard standing from the boundaries where you're going to put planting. It's not solid concrete going from side to side. It's quite easily remediable.
Thank you. I've no further questions, so thank you.
Right, well, somewhat later than usual, we'll take a break, and 10 minutes, please, back at 12:15.
Thank you, Inspector.
Thank you, sir.
It is 1:15. Can you all take your seats, please, and we'll resume. Oh, Mr. Winter, you haven't got Mr. Dudley again, is he? I know, we know he's here.
He's here, that's right. So
I take it he's on it.
yeah, he's on his way through. He may have just nipped into the loo.
Yeah. Do you want to?
I'm happy to start.
You're happy to start, yes. So it's Mr. Wintott's cross-examination of Mr. Woods.
Morning, Mr. Woods. Nice to see you again.
Afternoon.
Well, just about morning. All right. So what I'm going to do, Inspector, is just ask a series of questions covering this sort of structure, so you know where I've got to in my cross-examination. To start with, I'm going to ask some questions about approach, and then I'm going to ask some questions about valued landscape in terms of, again, approach. And then the third thing I'm going to ask some questions on is character. And then I will go on from there to speak about and build towards essentially what's the nub of the difference between the parties, really, Inspector. And that is this issue as to whether or not Mr. Woods is right to view sites A and B as, quote, intertwined with the wider Lydia Park site. So I'm going to move towards that issue and explore that through that line of questioning. And then when I've dealt with that issue, which is Mr. Woods's 9.2 to 9.8 effectively, I will ask a few questions about views. So I'll do it in that way. And Mr. Woods, so good morning. And in terms of approach, could you please take up what we call the purple book, which is Glavia 3, wherever you've got that. It's in the core documents at 11A.2, if you needed to look at it.
11.8.2.
Yeah.
Have you? Oh, I've got it. Good. I'm marked. Thank you.
Now, in terms of that document, if you can just turn up page 21.
Yes.
And in terms of the way one must go about assessing landscape matters, we see there from paragraph 2.23, sorry, it's a professional judgment, and we're looking 4 lines down at qualitative judgments. And nothing controversial about that. You go about it in that way, just as Mr. Dudley does. You're looking at qualitative judgments, yeah?
Yes.
And in terms of the next paragraph, though, well, that's where there's a little difference between the parties. So I want to just explore that with you. It's talking about the role of professional judgment. Now, I've looked carefully at your proof of evidence and how you put your experience at 1.4. Obviously, I know you anyway, but that's not relevant for the inspector. But you don't assert that you have any landscape qualifications. You're a planner, aren't you? And that's where your experience, your professional experience lies. That's fair, isn't it?
Yes, I'm not a landscaping consultant. I haven't got a professional qualification relating to landscaping. I'm a planner, and in my roles, either in local government or acting for local planning authorities or acting for appellants, a decision-making process looks at all matters, including landscaping. And through my experience, I make assessments every day in terms of the landscape impacts of proposals. So I am a professional, like the inspector is a professional. We'll have to make a judgment and balancing up, and in the planning balance, deciding, making decisions. There's nothing unusual about that.
But you don't, and it's no part of your evidence to say that the role of the professional judgment of a landscape architect is of no worth or value. You point out that all views need to be taken into account, but you don't differ from the approach laid out in 2.24, which is to ascribe a particular importance on professional judgment when we're looking at how significant a particular change is. And that's what I want you to focus on, that first line. The role of professional judgment is also characteristic of other environmental topics such as ecology or cultural heritage, especially when it comes to judging how significant a particular change is. So the question for you is, do you recognise the importance of a landscape architecture qualification when judging that as that paragraph says, or do you not recognise it?
If you're doing a landscape visual impact assessment, yes, but not in terms of assessing a proposal in terms of the character and appearance of the area and how it's going to have an impact on the landscape. Two separate matters.
Well,
This is the document aimed at a professional producing a landscape visual impact assessment. And I've been critical of the way Mr. Dudley sets out in terms of the impacts of the various appeal sites, more or less grading them all the same in terms of the visual impact. And so that's where I think he goes wrong. And so I think it's in terms of giving a weighting or whatever in terms of his evidence, I think it brings that into question.
So we'll explore how he's treated the various appeal sites as a matter of detail later. But in terms of a matter of approach, I just want to be clear that in terms of what the inspector is judging, he's using the evidence, including the LVIAs that have been produced, to judge how significant particular changes are, isn't he?
Of course he is. And as a professional, I think the key acid test in this case is to, on all of the appeals, but I refer to the two appeal sites I'm referring to, is for the inspector to go around to these various viewpoints that have been put forward by various parties, including the parish council, and to view towards the appeal sites and make a judgment in terms of that impact. And I don't think you need lengthy documents to make that assessment.
So I understand your position on that, and the inspector understands, and both sides of the room understand that the matter is for him to make a decision on. But the question I'm putting to you, and I'm grateful to your answer, that of course he's looking at how significant a change is, and that's what this paragraph is looking at, especially when it comes to judging how significant a particular change is. That's a matter where professional qualifications are of particular importance. That's what it says.
Not essential.
Not essential, but of importance according to the paragraph.
And you've well, the local planning authority's case has evolved. I won't go there, but in terms of the evidence that's been put in, I mean, the last evidence was put in. The inspector particularly said if there's been any changes. So we have new landscaping evidence. Well, the landscape hasn't changed since when you did your first evidence.
So, Mr. Wood,
so it's yeah, the point is, all of that is not essential to assess this proposal or the second proposal or the third proposal. No. It's not in the national landscape. None of the appeal sites are in the national landscape, and an assessment can be properly made from viewing the appeal sites from different vantage points or not vantage points.
So what's the answer, though, to the question that I put?
It's not essential, no.
But in terms of the paragraph saying it's a particular importance, I think you agreed with me in that sense.
I agree with you if you're doing a landscape visual impact assessment. I don't agree with the way Mr. Dudley's conclusions come to, because...
Well, that's a matter of detail.
It's a matter of opinion, but I'm allowed to qualify my answers.
And in terms of the rest of that paragraph, it's a particular importance that you've got that qualification when you're looking at how significant a particular change is. And it goes on to say why that is, because it says that with judgments that are made, they have to be based on clear and transparent methods so that the reasoning applied at different stages can be traced and examined by others. So in respect of that element, the need for transparency, you understand why that's important, don't you? And you wouldn't suggest that that's not important, that you can see why you've concluded what you've concluded, yeah?
Of course that's important, but if you come to the wrong conclusion, that's also important.
And the way in which you judge whether somebody's come to the wrong conclusion is by interrogating their transparent assessment, isn't it?
As I said, the acid test is of viewing the appeal site or appeal sites from what are said to be vantage points. That's the acid test. So you standing there and looking across and seeing what you can see in the context of what is there already, and what the difference will be.
So, I mean, I'm going to come on and go through what that transparent assessment entails.
Sure you are.
But it's not just a question of looking at it and saying whether you like it or saying what you think it looks like. The point of the transparent assessment is so you can interrogate the reasoning. And I don't see you as saying anything different. You've said that you've obviously got to get it right. My question to you is the way you judge whether you've got it right or not is by interrogating transparent reasoning. And that must be right. Otherwise, that paragraph is meaningless.
I've already given my answer.
Well, you agree with that, don't
I've
you?
already given my answer.
Well, can you
I
remind me?
disagree with it.
You disagree on what basis?
Well, I said, you know, when you look at, yes, there's a requirement to do things in a certain way in terms of landscape visual impact assessment. I understand that. We all understand that in this room. I'm sure we do. But the acid test will be where the decision maker would view the appeal site from public areas and what that impact will be. And there's no reason why the inspector can't disagree with Mr. Dudley on his conclusions.
No, but I mean, that wasn't what my question for you. You said that you disagreed with the importance of a transparent assessment. That's what I've written down. Do you really maintain that answer?
No, I didn't say that.
Well, please clarify exactly what you.
What I said
did
was,
say.
in terms of the landscape visual impact assessment, that's what it says you need to go through. But
So,
yeah, and yes, it's transparent in terms of what Mr. Dudley's put forward, but I don't believe he's come to the correct conclusion. I don't believe his weighting is correct. How can it possibly be in appeal site A be the same impact, virtually the same impact as the other sites? Well, you know, it's not credible.
So we'll come and look at the way he's dealt with appeal site A and appeal site B when we come to that stage of the process. But in terms of the approach, we're agreed that a transparent assessment is an important part of the process, so you can judge the reasoning. You don't say any different, do you?
It's part of the assessment for the LVIA.
And of course, you must accept, given your proof at 9.2 to 9.8, that you have provided no transparent assessment of any kind, either in respect of landscape character impacts or views, have you?
I haven't set anything out in detail in relation to that, because the council's reason for refusal was based on the impact on the national landscape when the national is not in the national landscape. It's a distance away from it. So there's no reason for me to do that.
So you so in terms of the way you've approached it, you haven't set out any detail or any transparent assessment, and you've said it's some distance away from the national landscape. You don't actually say that in your evidence anyway. You don't refer to the national landscape.
Well, it's a matter of fact, isn't it? Are you saying to me that it's not a significant distance away from the national landscape? Well, I don't think you are.
I'm not giving evidence.
I mean, it's not 2 meters, is it? It's not 5 meters. It's not 10 meters.
My question.
It's a substantial distance away, and it's not next to the national landscape. And previous inspectors haven't raised that as a concern.
Mr. Woods, I just want to understand your answer to the question from Mr. Lintott. I think you said you hadn't raised this in your proof because the council's reason for refusal just referred to the national landscape. It goes beyond that, doesn't it?
Well, it refers to the Arrogate Landscape Valley, which is a local designation.
It also refers to the countryside.
Yes, sir.
It doesn't just relate to the national landscape.
No. It doesn't, but what you need to look at in terms of the context of this borough is that 60% of the boroughs in the green belt. 88% of the green belt is in a national landscape. The additional national landscape is around Hazelmere in the south. %10 of the district is an urban area, and 30% is in the countryside. So where are you going to have, it's a rhetorical question, I know, where are you going to have gypsy and traveller sites be located? They're more likely to be in the countryside, and it's been accepted that this is a sustainable location. So it's in the countryside. And I find what is proposed is not out of character with the character and appearance of the area. And the council are vastly overstating their case against all of the appeals that we're considering.
So what you've just laid out there, Mr. Woods, is exactly why it's important to have a transparent assessment to judge the level of harm in a particular case, isn't it? Which is what you haven't done.
Well, because the level of harm in these particular cases is very limited, and that's quite straightforward. You can't see it from Stovolds Hill, so then you're looking as if you're seeing it from Dunsfold Road and the wider landscape, and the impact is very little. So I didn't, in my planning judgment, consider it appropriate or use of inquiry time to take lots of photographs from wider areas where it would demonstrate, because I've been there, that the impact is very low. It's answering a question that doesn't need to be answered in a way.
And in respect of the way in which one goes about providing that transparent assessment, can you turn within the purple book to page 71? And that's figure 5.1.
Okay.
And so this is the table, isn't it, which one sees that tells you the stages one needs to go through when assessing landscape character impacts. That's right, isn't it?
Yes, if you're doing a landscape visual impact assessment, yes.
And in terms of the first thing, or one of the first things one sees within that box of flow diagram of boxes on the left-hand side towards the top, do you see there that it's important to use landscape character assessments to establish the landscape baseline?
Well, the starting point is the top box, isn't it?
Yeah. So
the top box is describe the characteristics of the proposal, and then you're moving on to the study area and possible landscape impact effects, and then you're going to the character assessments are there. Yeah. I've already said in evidence in chief, but the character assessment doesn't properly reflect what is actually on the place on the ground, and that maybe because of the age of it.
So you don't dispute, do you, that that's the correct way of going about the assessment? You take a specific point in relation to the character assessments, but you should clearly take them, and the inspector clearly should take them into account, shouldn't he, in the way that the flow diagram indicates?
Yes, as all the other inspectors have at Lydia Park, yes.
And in respect of your evidence, you don't refer to the landscape character assessments at all, any of them in any way within your evidence?
I don't indeed, no.
Well,
no,
at all?
I don't refer to them, no. Because as I said, it's the impact of the proposed developments is so small in terms of how you view it from the receptors, which is the next thing on the list, is the receptors, is so small that it's not worthy of going into detail about it, because the character assessment of the area ignores the caravan park.
So in terms of assessing the receptors, the way that you do that is through looking at the landscape character assessments. That helps you identify what to assess. That's the next stage, isn't it? Identifying a series of receptors.
Well, you identify the receptors in terms of where the site is visible from.
And then you go on to, well, in terms of visibility views, but we're looking at character here. So in terms of landscape character, you're assessing it from the landscape character assessments, aren't you? You understand there's a difference between landscape character and views, yeah?
I've already said that the landscape character fails to acknowledge the caravan park that's there. So, you know, you have a landscape assessment on a wider area that completely ignores one of the major land uses in the area.
Just want to be, we'll come on and talk
It's not
about
a single
that.
caravan, it's a lot of caravans.
Yeah, I'm obviously,
So-
we'll discuss that, but in terms of the approach,
Mm.
I want to be clear in your answer here. You do appreciate that there's a whole different approach to assessing landscape character and landscape views. It's not just about whether you can see it, because the answer you gave indicated, well, because you can't see it, that's not
No, it's
relevant, is it?
twofold. It's twofold. What I'm saying is the landscape assessment that you're relying upon fails to take into consideration major land uses that are in that character area. So it's a failure of that assessment. So if you've got a failed assessment in the first place, and then you rely upon that, it's the wrong approach, isn't it?
Well, you need to rely upon the assessment and you need to describe it, and then you need to transparently give your reasons for why you would depart from it. But that wasn't the question. We debated that already. The point is that in choosing your receptors, that is an exercise you do from the landscape character assessments, isn't it? Because that's how you judge what's a receptor in the landscape to judge effects on.
If you can't see a site, you can't identify that as a landscape receptor. You will have a different quality of views for different points, and you've come up with different points, and that's your landscape receptors.
So I'm writing down that from your point of view, if you can't see a site, you can't have it as a landscape character receptor. That's what you've just said.
Well,
Is that fair?
if there's no, it can't be a receptor. Well, I suppose it can be a receptor, but the point where you have lots of views where you couldn't see anything. But that's not what your case is. Your case sets out, well, these are the receptors, these are the views you can see, and this is what you can see. And isn't it terrible? Well, it's not terrible.
So if you have a look at, for example, page 157 of the purple book, you can see there that we've got a definition section. And we've got landscape receptors defined. Third from the bottom.
Yeah.
So you see there that landscape receptors are defined aspects of the landscape resource that have the potential to be affected by the proposal.
Yes.
It's different
views.
from views, isn't it?
Well, okay, you could draw a line across, and then at 95 out of 100, you won't see anything. So that they're not affected by a proposal, are they?
Okay.
So therefore, you've honed in on those areas that, in your view, Mr. Dudley's evidence are affected. And what I say is that those views, there will be a very limited impact if you could actually discern the appeal proposals separately from the wider caravan site.
Okay.
Mr. Woods, I just want to understand your answer. Are you saying that the effect on character necessarily depends on visibility?
Yes, it's not definitional harm because it's not in the green belt. So it stems from the impact will be how you see the appeal proposals from public areas, because that is how it's going to affect the character and appearance of the area.
So character and appearance is all to do with visibility, in your view?
Yes.
Right, Inspector, I don't need to pursue that any further then, we don't know it. And so just to follow through the rest of the table then, and I don't think, as I say, to be fair to you, you differ from this as an approach.
Sorry, what page are we back to?
We're back to page 71.
71, thank you. Okay,
So we've essentially got two different strands that we need to consider coming down from what the likely landscape effects are, which is the middle box. On the left-hand side, we've got to look at sensitivity of landscape, and that's combined from judging susceptibility and judging value. Do you see that? Yeah.
I do, yeah.
And then on the right-hand side, we've got to combine and form a judgment on the magnitude of landscape impact.
Yes.
Excuse me. And then we combine those two factors to assess the the significance of the landscape effect.
Before we go on to that, one of the things that you do is you're judging the impact, the landscape effect, looking at the duration, and looking at whether it's reversible. And the point about the reversibility is a landscape enhancements that could be carried out.
Well, that's mitigation, actually, isn't it? So that's the box down.
Well, yeah, but he just says judge reversibility of effect.
Yes. Okay. But in terms of the approach again that we've got in those two boxes, you agree, don't you, that it's not just one consideration, it's a series of considerations that feed into an overall judgment of significance of landscape effect. And that's what one sees in that middle box, second from the bottom, combined to assess significance of landscape effect.
Of course.
So, and this is important. Do you understand that it's not just about how much something changes, it's about how significant the change is?
I understand that, yes. Yeah.
So it's not just about magnitude, it's about sensitivity as well. Yes?
Well, you just said how something changes.
Yeah, that's the magnitude. How much something changes is magnitude.
Yeah.
But you've also got to consider the sensitivity of the receptor, haven't you?
Yes, whether it's high, low, or whatever you judge that to be, but ultimately, it's for the decision maker, whether it's me making a decision at a recommendation to a planning committee, or it's an inspector making his or her judgment on a case. Then that's the balance you're taking into account.
Okay. So with that as a look at the approach, can we then, Inspector, move on to the second issue which I identified, which is that of valued landscape? And in respect to valued landscape, again, you don't provide any commentary in your evidence as to whether or not this is a valued landscape, do you?
No, I don't set out that it is or isn't a valued landscape, but I rely upon the framework and the fact that if it's an area outside of natural region, a natural landscape, then it will be a valued landscape. Then individually, it's down to the characteristics of the area, and I don't consider, and nor have previous inspectors considered, this to be a valued landscape.
Do you know what the definition of a valued landscape is?
Well, it's in the framework.
That's not what I asked.
Well, I haven't got it in front of me, so you read it out for me. You've got it there.
So it's not in the framework, but I'm just asking you an honest, open question. Do you know what a valued landscape is, how it's defined?
A valued landscape would be, for certain, a natural landscape. And it may be that other local considerations of a particular area mean that it might be a valued landscape. What we have is no inspectors, either on the north or the south side of the access road, considering this to be a valued landscape. So I don't differ from that.
So if you have a look at Mr. Wood's 18 to his main proof of evidence. So Mr. Wood's main proof.
Mr. Woods,
appendix 18. Sorry, Mr. Ward. Mr. Ward. Got a bit of a frog in my throat, Inspector. I'm sorry about that. So do forgive me. Mr. Ward, his main proof, and it's appendix 18.
I'm going to get the wrong one here.
Mhm. Well, yeah, it's page,
I've got
well,
up to
you're right,
12.
actually, yeah, they haven't, it's, yeah, I don't know, I've just got it marked up separately, so I've not, it's, yeah, appendix 18 of Mr. Ward's proof, but it's not, they're not numbered, the
It doesn't go
appendices.
to 18.
Is it a cranny?
It's, if you look on the front page, appendices, it's, sorry, it is rebuttal appendices, so you're right, yeah, that's my
Rebuttal.
mistake, sorry. So CW 18, which is with the rebuttal appendices.
If
So
I
that will
pass
have a
that-
different number.
What are we looking for?
Here's appendix
Right.
18 in
I'll
the
have to
rebuttal
log it back in
appendices.
again.
It's the Knoll Lane decision. Yeah.
And which core documents will I find this in, please?
Okay, so you need the rebuttal proofs,
Understand that, yeah.
and those are in CDA 8A,
Yeah,
and then it's the
yeah, yeah.
point 0.6. Okay, so hold on. So I normally write them down, but I still haven't done that on there. So I'll find the rebuttal planning.
Under Appeal B, sir, is it, or Appeal A?
It's the same under either. Yeah.
Oh, they do, because some are only in the other. Yeah. Okay, thank you. So,
Yeah. So it's CD 10A.5, Appendix CW 18.
right, I've got 10A,
Point five.
little 1 and little 2, then it goes to 11A.
10A.5. I'm just looking at it online with the core now.
Yeah, I'm trying to find it, but it's not listed. Is it the rebuttal
It's
evidence?
the last piece of rebuttal evidence. So it's the last bit in 10A.5.
So it's CD 10A.
0.5.
Okay. Lovely. Yes.
Excellent.
And it's Appendix 18. Right. Okay. Thank you.
So after that interlude, for which I apologise, if you within that decision, once you got it, which was Inspector Woolcock's decision, we were dealing with a case at Knoll Lane in Cranley on that occasion. So it was a case which was outside of the AGLV. But if you turn to page 9 of that decision and paragraph 36, you'll see that Mr. Woolcock is dealing with whether something's a value landscape. So can you just turn that up, para 36?
Yes.
So you see there that we were dealing with TGN 0221 because that's how you assess whether a landscape is valued outside of designated landscapes. And if you look down there, 3 lines, he says it has more than ordinary value in the context of the wider character and landscape area. My overall judgment is that the appeal site is part of a valued landscape. So the definition of a valued landscape is simply whether something has more than ordinary value.
Yeah. Well, I would agree with him on that particular site.
Well,
because I'm
not
aware of
asking
that
you-
site. I've been there. I've seen it.
Yeah.
I understand the reasonings.
But so
It's to do with the
approach.
landscape on the ground, and under that site you don't have lots of caravans around it being part of the landscape that is there.
Well, I'm not-
and
I'm
you don't
not
have, and you
asking you
have,
about that
what you have is an ordinary field that's in between the access road and Dunsfold Road. Nothing special about that piece of land whatsoever. So
as much
I
of a
agree with the inspector. In terms of approach, yes, of course, I understand that.
And do you see,
But in terms of approach, but to come to the conclusion that the wider area, that field in between the access road and Dunsfold Road is a valued landscape in terms of its appearance and quality, will be, in my opinion, completely the wrong decision to make.
And that's a matter of judgment. That's not a matter of
Well,
approach.
it is a matter of judgment,
So you,
but
you keep saying that, but I mean, ultimately, the inspector has to
you
form a
keep
view
saying
himself.
you keep saying it as well, so I can say it as well, can't I?
Well, I'm just asking
I'm
questions.
I'm here to answer the questions, and what I say, it is a matter of judgment, and the inspector in that particular case, and an oversight, I totally understand why the inspector came to that conclusion, because the quality of the landscape is much better.
Well, and then in terms of paragraph 31, you can see there at the bottom of that paragraph, if you have a look at it, we were considering LCA WW6 in that case, and we were looking at positive landscape attributes. And pausing there, that's one of the factors that the inspector needs to take into account. In our case, obviously, the positive landscape attributes within the LCA, yeah?
Well, yes, but the landscape assessment fails to take into consideration what dominates the landscape that is there. And so to say, oh, well, you know, to cherry pick and say that these are landscape qualities, it's not reflected on what is on the ground at the appeal side.
And in respect of what Inspector Woolcock found in that case, he found it as significant that the majority of the key positive landscape attributes apply to the appeal side. So that's something that the inspector needs to consider for our case, isn't it? And you differ in terms of the outcome, but it's clearly an important factor, yes?
It's an important factor, but it's like comparing chalk with cheese. As I said, I know the site that you're referring to. One of my co-directors was active for the local planning authority on that particular case, as you well know.
Well, he instructed me, so I do know.
But it's totally different. And, you know, I remember looking at the evidence, you know, my colleague showing me the evidence we're looking at, and he said, this is what I'm doing. And I said, well, of course you're going to win.
So what I want to move on to then is to look at the NPPF now. And can you turn up your copy of that, paragraph 187A?
Sorry, where I refer to it?
I'm looking in the NPPF.
Oh, I thought you said turn up my proof. Okay. Right.
Just wherever you've got your copy of the NPPF. So 187A, it's just the same paragraph that used to be 180A.
Yeah, I'm not sure it's been updated on the...
It'll be online, it will have been.
Just to take me a bit of time to get to it, because I've got to go back out and go back in again, so...
Yeah. Yeah, would you mind, Stephen?
Right,
yeah,
yeah.
Thanks.
Thank you very much.
So hopefully you're looking at 187A, not controversial, but just to remind you that when we're looking at valued landscapes, we're told there we're looking at protecting and enhancing valued landscapes, and we're reminded that that should be in a manner commensurate with their statutory status or identified quality in the development plan. Yeah.
Mm.
So
yes, that's what it says there. But the starting point in dealing with the Egyptian Traveller application and appeal in this borough will be looking at the criteria-based policy, and of course the criteria-based policy at the end refers to other policies that are applicable, and of course they're applicable. But you know, if you had to enhance, if it was a valued landscape, and you had to enhance it, you'd never get a planning permission, would you, for anything?
Right, but the question is just that's the correct approach. That's obviously
That's the correct approach.
protecting and
It sets it
enhancing.
out there, but I don't accept that the appeal site, for the reasons I've already stated, is a valued landscape.
And so we should be looking at the local plan, and where this is dealt with in the local plan is in policy RE3, isn't it?
Yeah.
So can we just turn up RE3? And in particular, I want you to look at the wording of that policy, which is on 127.
Probably in my statement of case, I think, isn't it? Just gonna get
Well, it's in CD 6.6 if you're looking online.
Can you just give me
Yeah, page 127, Inspector.
Sorry, I got that.
My one's only A5 and I've marked it. So
Yeah, I'll get there in the end. I just. Sorry, policy RE3. Yeah.
RE3, page 127.
Oh.
You might have it below the front.
Yeah, well, yeah. One two seven of the actual document rather than
Yeah, what 127
of the local plan.
of the local plan. Yeah. So obviously in local plan part 1, which is
Yes.
yeah.
if it helps, Mr. Woods, I think it's
No.
PDF page 64.
Oh, nearly there then, sir. Thank you. Thank you for that. Okay.
Excellent, good. So yeah, so Inspector, we'd agreed on the obviously paragraph 187 and that we need to look at the local plan for identified qualities, and Mr. Woods had agreed that's RE3. If we go to RE3, Mr. Woods, if you look at
Well, I agree that
two,
that's we look at protecting and enhancing valued landscapes, but I haven't agreed that an area of great landscape is a valued landscape.
well, I haven't said that. I've just
No.
summarised for the inspector, but because it'd been such a long time, just where we'd got to and what
Well, I'm
the
sorry.
stream of questions was. That's all. So we're looking at seeing whether it's a valued landscape.
That's priceless,
with
isn't it?
RE3. Yeah,
I'll take as long as I like in answering the question. So
that's fine. You do that.
yeah, I will.
So RE32, do you see that? The area of
I
great
see it,
landscape
yes.
value. And it says that the same principles
Yeah.
of protecting the AONB will apply in the area of great landscape
Fundamentally wrong.
value, so what's fundamentally wrong?
Well, you can't have a local landscape having the same protection as a national landscape.
So you haven't referred to policy RE3 or assessed anywhere in your
Well, I have
written
referred to it.
evidence.
It's referred to in my statement of case.
In-
It's
in-
referred to as a relevant policy in my proof of evidence.
In
so-
your proof of evidence, you haven't referred to RE3 in assessing whether something is a valued landscape. But what you're saying to me now is that policy RE3 is fundamentally wrong. Did you take that into account when deciding whether or not something was a valued landscape or not?
But
That it's fundamentally wrong.
It doesn't. This does not say how you assess a valued landscape. This policy.
Now, I've asked you a specific question, Mr. Woods.
No, well, I'm answering it in a specific way. This policy does not set out how you're supposed to assess something to whether it's a valued landscape.
Right. Are you maintaining your original answer that RE3, what I've just read to you, is fundamentally wrong?
To have the same principles of protecting areas of great landscape value as in a national landscape is fundamentally wrong. And of course, what we have is the review of the national landscape, and we know that the area around the appeal site is not a candidate for being put in a national landscape. So that's the test. So someone must be looking at it. Should this be a valued landscape? Let me think about it. No, it shouldn't. But that side should be.
So do you see there that if one reads on, it says it will be retained for its own sake and as a buffer to the AONB. Do you see that?
Yes.
And is that,
but the review means it won't exist.
Right. But we're looking, the inspector's got to apply the policy that's in place, doesn't he? He's got to apply policy RE3.
You can't apply.
Is that right or not?
Can you let me finish, please?
Well, but please answer the question.
I will if you let me actually start the answer. It'd be really helpful. So, when you're looking at it, what you need to look at, there has been a review of areas of outstanding natural beauty, what is now a national landscape, and we're on the final line of it. And the final line says that this area, by this appeal site, Appeal A, Appeal B, Appeal C, Appeal D, is not a candidate for inclusion within a national landscape. So that's the proper assessment that's been carried out. Not to have a policy that says, oh, you have the same, it's a bizarre thing to say that you will have the same, it carries the same weight as a national landscape. Completely wrong approach, and that's not the approach set out in the framework.
So the inspector needs to apply that policy, which has been through examination, in the way that it's drafted, doesn't it?
Yeah, but we've had the framework has changed since then.
What, you mean the MPPF has changed?
Yeah.
In what way has it changed that's material to this question?
It says there, looking at valued landscapes and how you assess valued landscapes, by having a local policy, saying that a local designation carries the same weight as a national designation. So I'm just clearly that's wrong.
Just asking you what the change is to the MPPF that makes any difference at all to that determination. What's the change that's been since that was written?
Well, the change relates to looking at landscape in a particular way and recognising what is a national landscape, what isn't a national landscape, and then you have the review that I've already said about. That's changed. But so there won't be an area of great landscape value. It won't be there anymore.
So we're conflating two things. You're not suggesting the MPPF has changed. You're suggesting that.
Well, it has changed.
In what way has it changed?
Well, it's changed in lots of ways.
In respect of what's significant for this determination. Okay. Has it changed in a way that's significant for this determination?
Local planning policies are supposed to be in accordance with the framework. And I don't see anywhere in the framework where it says you give the same weight to a local designation as a national landscape.
But that was a matter for the inspector examining the plan to decide whether it was in conformity with the MPPF.
Well, at that point in time.
Yeah, but there's not been a change since then.
If someone didn't object to it, then it won't be taken into consideration. And the point is, previous inspectors, all the previous inspectors relating to Lilia Park, whether the appeals were allowed or dismissed, set out, don't say that this area of great landscape value should be elevated to a valued landscape. It's nothing to help you in the previous inspector's decision. What you're asking this inspector to do is to do something completely different from all of his colleagues.
So, and in terms of judging what the plan tells you to do in respect of this area of great landscape value, can you have a look, please, at 1337, which is on page 123, 13.37.
I don't know if it's fair to interrupt, but just to ask that the witness is referred to the preceding paragraphs to see 137 in context.
Witness, I mean, I haven't asked a question yet, but the witness can have a look at, and he's already referred to 1335 in his previous answer. So just let me know when you're there, Mr.
Yeah, I'm
Ross.
there, yeah.
Okay. So the test that relates to the area of great landscape value in 1337 is by protecting and enhancing valued landscapes. That's the same test as within the NPPF, isn't it?
Well, for valued landscapes,
Yeah.
but this is, it doesn't say in the local plan that an area of great landscape value is a valued landscape.
So your case, I just want to be clear, is that in the light of what's in 13.37, that doesn't tell you that the area it's describing, which is the area of great landscape value, is a valued landscape. Is that's the case you're putting to the inspector? That's your judgment?
Well, it doesn't say that, and the preceding paragraphs explain, and of course the inspector would have taken this into consideration, the examining inspector, when considering the plan, that actually AGLVs will disappear, and they either become a valued landscape as a national landscape, or they're just countryside, or in the green belt.
But we're not there, are we? We've got to deal with the
No,
case
but yeah,
where we are now.
that's how you convince the inspector, I'm sure, the examining inspector, that yes, we're okay then, it's short term, that's what it's going to be, but we're nearly there, aren't we? And there's no contrary evidence.
So
There's no contrary evidence. The evidence is that the appeal sites are not a candidate for inclusion in the national landscape. So if they're not a candidate, they won't be included.
in terms of the test in policy in 13.37, it is absolutely clear by use of the words protecting and enhancing valued landscapes that that's talking about this local landscape designation, isn't it? It's talking about the AGLV.
Right. Can we, please? Well, that's just planning systems should contribute to and enhance the natural local environment, protect the natural landscape. Yes, that's why the review is taking place, to have a proper national policy rather than a series of local policies to say what landscape is truly important, and that the truly important landscape will go into the national designation, and the local designations will disappear. Waverley and lots of other councils. So it's a device that's been put on land that, oh, let me think, it's not in the green belt, it's not in the national landscape. I know what, we'll have a local designation.
So in terms of paragraph 13.38, it talks about in addition to the AGLV, there are other local landscape designations. But 13.37 is dealing with the AGLV.
Yes, I understand that, yeah. But the whole thing that is headed under local landscape designations. So you read the two paragraphs as well. And you have to read in context the preceding paragraphs, which I've already referred to.
And then, Inspector, I'm conscious of the time, but if you just let me just finish on this point. So if we have a look at CD 11A.1, the Grattan Chase decision, just to see then how inspectors have addressed it. So 11A.1.
Okay.
I'm not there yet, sorry. I'm taking time now.
Oh. I'm usually the last one. So.
Sorry, it's just sticking. Oh, yeah. Right, I've got it now.
So, and Inspector, it's paragraph 10 of that decision on page 3 again.
Yes.
So the way in which, as a matter of approach, this inspector addressed matters is dealt with in paragraph 10, where the inspector says a landscape is a sum of its parts. The landscape in question is the AGLV. It would make little sense to assess whether the site itself constitutes a valued landscape. And so what the inspector has done there is to take the fact it's an AGLV and assess it as a valued landscape.
Well, no, he doesn't say that, does he? Where's he
Says
say that?
precisely. Do you see? And if there were any doubt, in the paragraph above, he says, I share the council's view, the AGLV should be considered as a valued landscape. So he says it's a valued landscape.
Well,
He
he's
says
referring
why.
to the site specifics of that site.
He's not doing that.
And you know, you need to look at it in relation to that particular site. You can't just, otherwise you say, well, all AGLV must be a landscape, valued landscape.
That's exactly what he
But
says.
Well,
That's the point.
No, I don't think he does.
Because that's why he says it would make little sense to assess whether the site itself constitutes a valued
So
landscape.
what you're saying, what you're putting
not-
to this
it's what the
inquiry, what
inspector
you're
said.
putting to me is that all the other inspectors relating to Lydia Park, whether to the south or the north, were all wrong. When they didn't say that it was a valued landscape because it was in the AGLV.
What I'm putting to you is that as a matter of approach, where you're dealing with a designated landscape, you don't descend into the detail of assessing whether the site itself constitutes a valued landscape. You look at the designation. That's the correct approach.
No, I don't accept that.
But that inspector
I don't accept
said
that. That inspector came to that conclusion, and in doing that, he said he appreciated the different approach was taken by an inspector on another appeal. So, but what we have here, you have a site that's not closely related to any of the appeal sites. And the other one you put to me, again, was not closely related to any of the appeal sites, where the inspector considered they were valued landscapes on the basis of what's there. What we have on the appeals that have been decided in this area, none of the inspectors have said it was a valued landscape.
and we've already looked at.
So they're all wrong. That's what you're saying. That's what you put into me.
We've looked at CD 8A.4 already, which is Mr. Willow's decision at Burnt Hill that we did last year in paragraph 48. And what he said, if you want to turn that up, you can.
I will, please.
You can look at it in CD 8A.4. And when you get to that, you'll need to look at Appendix 16. So it's the last one.
Yeah, I'm not there yet. Eight A, last appendix, yes?
Yeah.
Okay. Eight A4, did you say?
Yeah, 8.4, and it's the last appendix in that 116.
Appendix 16, Waverley Appeal Decision. Notice,
You've
yeah.
got it, yeah.
Okay.
So, and when you're there, it's on page 10, paragraph 48.
Yes, got it. Yep.
Yeah. So you'll see that in paragraph 47, the context for 48 is given. So Inspector Willow says, I'm reading from the second line down, the site falls within an area of great landscape value as defined by the local plan. Policy RE3 states that new development must respect and where appropriate enhance the distinctive character of the landscape in which it's located. It adds that the same principles for protecting the AONB will apply in the AGLV, which will be retained for its own sake and as a buffer to the AONB. So that's what we've already discussed a few moments ago.
Yeah, that's what the inspector says in relation to that particular site.
And he's summarising.
And what we have.
I haven't asked you a question yet.
Oh, right, okay.
So that's the context, and we've discussed that. 48, given the long-standing inclusion of this land within the AGLV designation, it is clearly part of a valued landscape. Carrying out of unauthorised works at the appeal site does not alter that. In any event, while the qualities of the individual parts of the AGLV may vary, it seems to me that the designation is a reflection of the overall character of the AGLV, and it is the landscape as a whole that is valued. So what he's saying is you look at the landscape as a whole, and that the AGLV as a whole is a valued landscape. That's what he's saying there, isn't it?
I can see what he's saying there, but I don't accept that. And if it was actually, in the council's eyes, a valued landscape and should be retained as such, it begs the point of why they allocated it for a gypsy and traveller site. So they, on this valued landscape here, they allocated it as a gypsy and traveller site.
Do you know the circumstances of? I don't
It's a
suggest
travelling show person site.
So you know
I
historically.
do know that. Yeah,
so that
yeah.
it was a traveller's show person site from the 1970s.
That's why I find it strange that the inspector comes to that conclusion in respect of that, because it was a travelling show person site. So obviously it had an impact of what was there. The council allocated it for gypsy and traveller side. What was proposed was too many pitches, so it had an impact on the wider area. So perhaps that's what it's referring to. But I don't accept that just because something is in an AGLV, it should automatically become a valued landscape. That's where we differ.
I understand that, but you understand that is what Inspector Willows has found.
Yes, for some reason on that particular site, and that's he's come to that conclusion, which I have to say is a little bit odd.
All right, Inspector, I think that is the end of my second topic. So we've got to 1:20. If that's a convenient moment for you, then that probably would be a convenient moment to break.
Okay, yes, we'll take the lunch adjournment now. 3/4 of an hour sufficient? Well, there are matters ongoing, I think, in discussions that concerning conditions that you.
Well, I would appreciate it if we carry on while the experts confer.
Oh, you mean, yeah, I don't think the inspector's suggesting that we take longer while we're waiting for them. I think
I just want to check that there's nothing else that
needs to happen.
needs to involve parties in
No, I think from my part, 3/4 of an hour probably is fine.
Sorry, Ms. Massaggio, you're happy with that?
No, yes, ma'am.
Good. Okay, well, we'll adjourn now and resume at 2:05. Just initially in the adjournment, I'd just like to have a word with the three advocates, please, in my room.